Well, let's find out how the government's approach to a new round of consultations with Indigenous peoples is being received. Stewart Phillip is the Grand Chief of the Union of BC Indian Chiefs. He joins me now. Chief Phillip, first of all, thanks for giving us some of your time today. It's much appreciated.
Good afternoon.
The federal government has announced today no appeal to the Supreme Court of the ruling from the Federal Court of Appeal rejecting the permits for the project, and the appointment of a retired Supreme Court judge to design and oversee a new consultation process with affected Indigenous communities. So what's your reaction to how the federal government has decided to proceed?
Well, the overall reaction to all of this is pretty much that the circus is continuing. Here we go again. The recent announcements on the part of the federal government in relation to the Federal Court of Appeal decision have been somewhat frantic and rushed. We were recently told we had a week to register, and I believe that time frame has lapsed, and we're not impressed with this flurry of activity and the the sense of self-interest and urgency from the government of Canada, the government of Alberta, and industry. It seems the intent is to reactivate the project. Consultation seems to be somewhat of an afterthought. And you may recall Prime Minister Trudeau made a commitment once again that there would be no tricks. And yet here we are once again with what appears to be a deliberate effort to circumvent the Federal Court of Appeal decision. And the notion of having a retired Supreme Court justice is just more of the razzle-dazzle, so to speak, of this whole process. Consultation is a serious undertaking, very high legal standard, and must be multi-seasonal in its timing. The conditions on the land change throughout the different seasons. And we must bear in mind that the ultimate goal here is consent-based decision-making.
Okay. Do you think that's what the government has in mind when it says the minister said today, minister says, I'm keeping an open mind in the consultations, but he's also making it clear the project's going to get built. What does that say to you?
It is yesterday's law, and you must understand that. We need to aspire to consent-based decision-making, and the focus on consultation, again, is were the legal standards from yesterday. So we need the consent, the clear, unqualified consent of the Indigenous nations along the pipeline route, along the where the tankers will go through a heavily congested seaway. That's what we need to achieve here. And we all know that there are not only First Nations, but British Columbians that are really adverse to imperiling our Salish Sea and the multitude of watersheds, which host the iconic wild salmon runs here in British Columbia, killer whales in the Salish Sea. So there's a lot at stake here.
So what you're saying sounds a lot like you believe that Indigenous groups should have a veto over this project. I don't think that's not a surprise to people. I don't think the minister says a veto's not on, and so I guess what I want to know is, if this process as it moves forward, will your chiefs take part in a consultation process as described by the government?
Well, first of all, we reject your racist notions of a veto. The UN Declaration gives us the right to say yes or to say no. And, that's the law of the land. In terms of participation, we will be consulting with our legal teams and other groups involved in this issue, and we'll see where we go from here.
Okay. Let me ask you, I think you've already stated that the only proper way to proceed with all of this is to abandon the project entirely. Is there any consultation process the government could design that you would support?
It's consent-based decision-making. That's the standard.
Mhm.
And, the issues in this whole affair are not new. Our concerns are very grave concerns we hold for the environment, pristine environment and water systems here, the marine ecosystems in British Columbia. And we believe we have a fundamental right, a fundamental human right, to protect the safety, health, and well-being of British Columbians, of Indigenous peoples, and we fully intend to do that.
Are you prepared to go to court to fight the government at the end of it? Says it's fulfilling its constitutional obligation under the federal court ruling, and it's opted not to go to the Supreme Court on this issue. At the end of this consultation process, are you prepared to take the government to court at the end of that? Because the government's going to say it has satisfied its constitutional demands. Will you take them to court?
Absolutely. At the beginning of this conversation, we talked about the somewhat dodgy approach to this whole renewed notion of outdated consultation as opposed to consent-based decision-making. And if we believe that once again we have to rely on the courts to uphold the legal standards, the constitutional rights of Indigenous people, we're certainly prepared to do that.
All right. Always good to get your perspective. Grand Chief Stewart Phillip in British Columbia. Thank you for your time, sir. Appreciate it.
Thank you.